Good afternoon, my name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to provide you some updates regarding recent immigration news. Well, first of all, for those of you who are waiting for the hearings in court, for those whose hearings in immigration court were cancelled due to COVID, you need to know that unless your court already adopted a specific hearing schedule, all non-detained hearings have been postponed through September 11th. For example, in New York, all non-detained hearings have been postponed through September 11th. And moving forward, what we can expect is that master hearings are going to be done via phone, meaning that your attorney, the government attorney, and the judge all will be present at your hearing, perhaps without you, but they will be present at the hearing via the phone. For individual hearings, it will be different. For individual hearings, most likely you will have to appear in person, unless you would be the person who would want to have the hearing telephonically, or perhaps if the judge orders the hearing to be done telephonically. So for now, non-detained hearings are basically cancelled through September 11th in most courts. Once they will start going on, what you can expect is that master hearings will be over the phone, and individual hearings, you will have to check with the judge and with your attorney that individual hearings most likely will be done in person, unless there is a special order to have your hearing done telephonically. Okay, so that's for those who are in immigration court proceedings. Remember that if you had deadlines to submit some documents to court, you still must comply with those deadlines. If you moved, you still have to inform the court, even though your hearing was canceled, right? For now, canceled, of course. It will be rescheduled. You still have to let the court know that you moved. It's your obligation to inform the court that you changed your address. It's very important. Another important news is that Form I-765, an application for employment authorization, has been changed. Right on August 25th, now we have to use a new addition to the Form I-765. What changed? Are there any significant changes in the new edition? Well, there are some significant changes, but for those who are seeking to receive employment authorization based on asylum pending status, for those people, you have to now answer certain additional questions. For example, how you entered the United States, if you entered legally through a border checkpoint or illegally, if you entered illegally or between the point checks, have you surrendered yourself before a Department of Homeland Security officer within 48 hours? If not, why? So those are the questions. The questions are related to the new rules regarding employment eligibility for those who have pending asylum cases. So that form will be, the new edition, of course, will have to be used also by those who are seeking to renew the employment authorizations. Remember that. So I suggest that you take a look at the form and consult with your attorney in case you believe that some of those questions will be answered as no, okay, just in case. So these are important news for right now. We also have some other news, like new lawsuits being filed to challenge certain restrictions on adjustment of status for TPS holders. You may be aware that a TPS holder or a holder of temporary protected status is usually entitled to advance parole. Advance parole is an authorization that allows a person with a TPS status to travel outside of the United States and to come back without losing TPS status. So at some point, USCIS stated that if persons who used to have orders of removal and now have TPS status traveled on advance parole and come back, such persons' advance parole entry would not in any way alter their initial entry to the United States. So basically, the advance parole entry would not count for legal purposes for these people, okay? As if it never happened. So there is a lawsuit that's been just filed challenging that fact, because under USCIS regulations, a person who's paroled is paroled. And the big difference in this situation is that a paroled person now has a legal, so-called legal entry, sufficient for him or her to file for adjustment of status, for example, based on immediate relative petition, okay, spousal petition. So that's an important news. We're going to be monitoring the development of that lawsuit, because it may change to significant shift in policy regarding adjustment of status for TPS holders. It's very important. And there are some other lawsuits going on. There is a lawsuit challenging President Trump's proclamations, bans related to DV lottery entrants, family members of certain permanent residents, and family members of US citizens. So that litigation, as you may be aware, that litigation may really help people to come to the United States. Of course, provided that COVID restrictions will be finally lifted. So these are the news for now. I also posted some videos about DACA updates. Update for those who are seeking to renew the DACA status, very important changes in policies, and some recent asylum announcements. So thank you very much for watching. Like, share, and I hope to see you soon.